I'm here with Womble Carlyle Land Use lawyers John Cooke and Mike Thelen. The topic we're talking about is development agreements. Mike, tell me, what's a development agreement?
Basically, at its core, a development agreement is a contract between a local government and a landowner that vests in the landowner certain rights for the development of a particular piece of property. And it provides the developer and the local government with the terms and conditions that will govern the development of the property over a period of time, the type of infrastructure that will come along with the development of that piece of property, and so on.
John, could you tell me a little bit about the specific features of a development agreement and how it differs from other types of contracts?
Development agreement is really a specialized contract between a local government who has zoning jurisdiction over your property and you, the property owner or developer. And it really addresses principally two things. One, the development of private and public infrastructure necessary to support your project. And secondly, establishes sort of a plan by which your project is going to occur over a period of years. So the idea is to set the rules and regulations for the project for the entire life of its development. So there is certainty both for the landowner and for the local government.
Mike, why would a private party like a developer and user of property want a development agreement?
Ordinarily, and by law, the development agreement will apply to a large-sized project of 25 acres or more, and will also exist for a duration of time, usually 20 years, no more than 20 years. When you're investing substantial amounts of money and time, the risks are inherent, and a development agreement will allow the developer and the owner of the property a chance to minimize some of that risk through certainties as to the laws that are going to apply, and again, the phasing and the infrastructure that is going to accompany the development.
What does vested rights mean practically?
The law is constantly changing. However, your rights are established under whatever law exists at the time they were established. So even though the law changes, your rights to continue to develop your project have been set under the law that you knew when you made your financial decision to go forward with your project. So it provides great certainty in terms of the impact of laws on the profitability of your project. Likewise, for the local government, it has set definitely the rules that you will comply with as you go forward. So they have a pretty good understanding of what your project should look like when it's completed.
But why would a local government want to pursue a development agreement?
Because it only works for large projects that are developed over time. It is a tool that is attractive to the local government because it allows them to encourage that kind of long development of a project with extensive impact to their community. So it can dovetail rather nicely with a large economic development project if you were looking for creating new jobs in your community. It also is helpful to the local government because they know that this project will develop at a certain pace. Therefore, they can build the roads, the water, the sewer, the other public infrastructure at a pace that it will serve your project, and neither too far in advance and therefore not used, or too far behind, causing an adverse impact to the public.
How does a private party go about seeking a development agreement with a local government?
Like anything else when dealing with a local government, it's important first to know your local government and to know the history of that local government in the context in which you're operating. And here, you'd want to know the local government's experience, if any, with the development agreement statute and with the entering into of development agreements. As to whom you should contact at the local government, that also will depend on who is really the driving force for these types of planning issues. In some instances, it might be the county manager or the town manager that you contact first. In some instances, it might be the county or the town attorney. And in still other instances, it might be the planning director for the particular county.
John, could you tell me, should I involve a lawyer in this process? And if so, at what point should I involve a lawyer?
Early on, you want to talk to your attorney about a development agreement. But these are very specialized agreements that have very specific statutory requirements that must be in each agreement. And therefore, you really need to fully discuss before you even start thinking about this idea with your lawyer. Is this a good idea for my project? How can I plan for it? And if you decide that it's worth going forward with, then your next strategies is really what Mike was talking about, is how do I approach the local government? Do you want, for example, in addition to a development agreement, do you want a water agreement? Do you want a sewer agreement? Or is it going to need a lot of transportation support?
Mike, could you close this out? Who wins with a development agreement in place?
Well, I think if the process is done carefully and correctly, both the local government and the property owner win with a development agreement in place. It sounds cliche, but I think that's true. It provides that certainty we had mentioned earlier. For the owner, there's a substantial investment of time and money, and the certainties that come along with a development agreement are going to minimize the risks that are inherent in any development project of this size.
John, Mike, thank you both for your time. For more information on Womble Carlyle's land use practice, visit WCSR.com.